Greetings, 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 peace. It is Empress ShayMarie back for another recording. So, as you know, we stopped on page 48 of the Gilbert Law Summaries on Trust. So, I'll be picking up today on page 49, which is going to be starting off with talking about Gilbert exam strategies. So I'm going to try to get through this strategies as well as the next chapter as much as I possibly can over the next hour or two. I hope you all appreciated the first read, and I will definitely be back for more. This is definitely a much needed book for us to be able to dissect and gain the knowledge from. So I hope you are appreciative. And if you'd like to make a donation, you may do so by checking out the Cash App information or my Chime account in the description area of this video. If you'd like to schedule a consultation with me, you may also do that by emailing me or checking out my Calendly calendar for my hour um, consultations. Okay, so getting started with the book, Gilbert Exam Strategies. Problems in the field of trust invariably require you to determine the nature of the relationship that has been created and the rights and obligations of the parties in light of that relationship. The following analysis may be helpful in resolving such problems. Be sure to preview the key exam issues at the beginning of each chapter. 1. Nature of relationship. As a first step, consider whether the relationship has been created is in fact a trust. Except where the law implies a trust, there must be some effective expression of intent by the owner of property to create the particular status that the law regards as a trust. The parties' own expressions of intent are of course significant, but also consider A, is there a bifurcation of title so that the legal title is held by one party and beneficiary ownership by another? B, is there in fact a fiduciary relationship between the holder of legal title and the claimed beneficiary? C, is the relationship one with respect to property rather than one involving merely personal obligations? And D, does it impose equitable duties upon the holder of legal title? Enforceability as a trust, number 2. Assuming that the relationship intended is in fact an express private trust, consider whether it is enforceable as such. A, are the essential elements of a trust present? There must be 1, a present trust intent, 2, designation of trust res, 3, identification of beneficiaries and trustee, inter vivos trust only, and 5, a statement of valid trust purposes. B, has the trust been effectively created? Number 1, inter vivos trust. If created by the settlor during his lifetime, A, is there an effective present trust transfer of the trust res? B, is the statute of frauds applicable? If so, is there a sufficient writing, or if not, is there some way around the statute, such as part performance, estoppel, purchase money resulting trust? C, is the trust testamentary in effect such as that statute of wills is applicable thereto? Number 2, testamentary trust. If created in a decedent's will, is the trust executed in compliance with applicable wills law? including the doctrines of incorporation by reference and facts of independent significance. C. Is the trust purpose valid? Consider not only the express trust purposes, but also whether the terms of the trust would violate any rule of property law, such as the rule against perpetuities, the rule against suspension of power, alienation, the rule against accumulation, etc. Number one, charitable trust. If the trust is exclusively for the benefit of the public or some large segment thereof, it may be held charitable, in which case special liberal rules are applied. No identification of beneficiaries required, may last perpetually. Cyprus doctrine may apply, and some restrictions may apply as well. Mortmain Acts. Remember, however, that to be considered a charitable trust, the purpose must either fall within one of the generally accepted categories of charity or be sufficiently of interest or beneficial to the community. Number three, rights, duties, and liabilities as between parties to the transaction. The rights and remedies available to the parties of the transaction turn on whether an enforceable trust relationship exists. A. Where there is an enforceable trust, the rights and duties are those created under the trust instrument by law. Consider the rights of each party separately. Number one, rights of beneficiary. A. To obtain an equitable decree compelling trustees' performance. B. To obtain removal of trustee for breach of trust. C. To obtain damages against trustee. See below. D. To compel modification or termination of trust under appropriate circumstances. And E. To obtain an accounting as to her share. Consider allocation of income to trust and expenses of trust administration and determining share of income beneficiary and remainder beneficiaries. 2. Rights of settlor. A. To exercise any right reserved by him in creating the trust, to revoke, modify, etc., or inferred by law. And B. To compel trustees' performance where trust created by contract between settlor and trustee. 3. Rights, duties, and liabilities of trustee. Rights of trustee. 1. Right to exercise powers created by trust instrument or inferred by law. A. Consider the source and scope of trust powers. And B. Consider whether exercise is mandatory or discretionary and the scope of judicial review. 2. Right to compensation for services and indemnification from trust estate for expenses and liabilities incurred in proper administration. B. Duties owed to beneficiary. Duty to act with care, skill, and caution, i.e., prudence, in administration, investment, and management of trust estate. And 2. Duties of loyalty and impartiality, in avoiding conflict of interest in personal contracts with beneficiary or trust estate, self-dealing, earmarking, and segregating assets. C. Trustees' liabilities. 1 is a measure of liability for breach of trust duties, profits, losses, and interest. And 2, defenses to liability, consent or ratification by beneficiaries having capacity to consent. B, where there is no enforceable trust, consider whether the apartment or pyramid trust intent can be enforced, and if not, consider what other remedies may be available. Contractual. 1, if consideration was given for the unenforceable trust promise, Is specific performance available to compel effective trust transfer and render the trust enforceable? In any event, damages or other relief may be available. 2. Resulting trust. Where an express trust is totally invalid and excessive trust res is conveyed, a resulting trust may be imposed in favor of the grantor to effectuate his presumed intention. 3. Constructive trust, where an express trust is merely unenforceable and the grantee's retention would constitute unjust enrichment, a constructive trust must or may be imposed, but consider whether it should be imposed in favor of the grantor or the intended beneficiary. Number 4, rights of third parties. The question may also invoke third parties who have dealings with the trustee or the trust estate or who seek to reach the beneficial interest under the trust. A. Assignee of beneficiary's interest. In determining the rights of someone to whom the beneficiary has made a voluntary assignment of his interest, consider whether there is a valid spendthrift restraint. Also consider priority as between successive assignments of the same right. B. Beneficiaries, creditors. In determining whether creditors can reach the beneficiary's interest, consider the validity and effect of spendthrift or similar restraints and the scope of protection afforded thereby, principal and or income. C. Settlers, creditors. Consider whether creditors can reach the trust estate. 1. On the theory that the settler has reserved powers over the trust, or 2. On the theory that the trust transfer was a fraudulent conveyance. D. Contract creditors. Consider whether the trustee is personally liable on contracts executed by him on behalf of the trust, the effect of any disclaimer of liability, his right of indemnification from the trust, and whether the contract creditors can reach this right. E. Tort creditors. Consider whether the trustee is personally liable for torts committed by him or his agent in the course of trust administration, the scope of such liability, his right of indemnification from the trust, and whether the tort creditors can reach this right. Author's notes. References are made throughout this summary to the Uniform Trust Code, UTC, which was promulgated in 2000 by the National Conference of Commissioners on Uniform State Laws, the 1959 restatement second of the Law of Trust, referred to in this summary as the second restatement or Rest 2D, is being replaced by a new restatement. The third restatement, or Rest 3D, a preliminary volume on the Prudent Investor Rule, was published in 1992 by the Law Institute and has been codified directly or by adoption of the 1994 Uniform Prudent Investor Act, UPIA, in nearly all states. Another 3 volumes, 1 through 92, have now been published. The third of these volumes end with chapter 17, 90 through 92, which incorporates in proper sequence the Prudent Investor Rule, originally section 227 through 229 in the second restatement and 192 preliminary volume. The fourth and final volume is now underway. You will also find references to the treatise Scott on Trust, first published in 1939 by the late Professor Austin W. Scott. Professor Scott published 2 more editions in 1956 and in 1967. A fourth 12-volume edition published over a period of years from 1987 to 1991, was the work of the late Professor William F. Fratcher. The citations in this summary are to that edition. The first 4 volumes of the upcoming fifth and more concise edition by Professor Mark L. Asher, entitled Scott and Asher on Trust, have recently been released. Chapter 1, Introduction. We'll go over key exam issues, definition of fundamental terms, classifications of trust, and trust distinguished from similar relationships. Key exam issues. When the nature of a legal relationship in your exam question is not stated or self-evident, you will need to determine whether that relationship is properly classified as a trust or as something else. Remember that other comparable relationships may resemble a trust, such as a bailment or an agency, and must be distinguished in order to make a determination of trust. This determination of trust or no trust may itself be the answer to your exam question, or it may be only one step in determining the ultimate issues of the rights, burdens, and duties of the parties, which depend upon the classification of a trust or non-trust relationship, and possibly upon the type of trust. Note, this chapter introduces the trust and its various forms, but more elaborate definitions and descriptions are presented elsewhere in this summary. A. Definition of fundamental terms. 1. Trust. A trust is a fiduciary relationship with respect to specific property to which the trustee holds, usually at least, the legal title for the benefit of one or more persons who hold equitable title as beneficiaries. Thus, 2 forms of ownership, interest, legal and equitable, exist in the same property at the same time. Rest 3D2. Or restatement 3D2. Example, a testamentary trust created by settlers will leave the residue of my estate to, it says, quote, the residue of my estate to trustee in trust to hold, invest, and manage the property and to pay the net income annually to beneficiary for as long as beneficiary lives, and upon beneficiary's death, to distribute the principal to beneficiaries then living issue by right of representation. Other terms of settlers will spell out in some detail other rights of the beneficiaries and trustees' powers and duties. A. Legal and equitable interest. An earlier view was that the entire ownership was in the trustee, subject only to an obligation, enforceable in equity, to use the property for the benefit of the beneficiary or beneficiaries. The interest of a beneficiary was regarded as merely a personal claim or choice in action, which equity would protect. A few states may still retain this concept, but the vast majority of modern authorities now speak in terms of the trustees' legal and beneficiaries' equitable interest or title. See infra subsection 217 through 218. B, property. Number 3. Because a trust is a relationship with respect to property, and because the beneficiary acquires an interest in the property, the normal rules for transfer of property and for the creation of property rights apply to the creation of trust, such as conveyancing rules apply in creating trusts of land. An exception is the declaration of trust, by which a property owner may declare himself trustee of the property for the benefit of others. Most trusts are created by will or by gift or do not require consideration to be enforceable and effective. C, separable interest, because the variable or the various equitable and legal interests in property are separable. Each can generally be dealt with, such as divided or i.e. divided, alienated, etc., independently of the other. 2, settler. The settler, sometimes called the trustor, donor, transferor, or grantor, and in current usage, the term is also applied to as a testator, is the person who creates the trust, i.e., who intentionally causes it to come into existence by inter vivos transfer or declaration, or by will. Number 3, trustee. The trustee is the individual or entity, often a bank or other corporation, who holds legal title to the trust property. There may be co-trustees, i.e., more than one trustee, and the trustee or one or more trusts of the co-trustees may also be a beneficiary or settler of the trust. Number 4, trust property. The trust property, or res, is the interest that the trustee holds for the beneficiaries. It may consist of real or personal property or both. The most common subject matter today is intangible personality in the form of securities, stocks, and bonds. Although it is generally stated above that the trustee has legal title to trust property, some or all of the res could itself be an equitable interest assigned to the trust, in which case the trustee would hold an equitable title. Example, settler transfers her interest in another trust to trustee to hold upon a new trust for the benefit of friend for years, remainder to child. Trustee holds an equitable interest for friend and child. Beneficiary, number 5. A beneficiary, sometimes called Certificate Trust or simply Certificate, is a person for whose benefit the trust property is held by the trustee. Most trusts have a number of beneficiaries, usually one or more life beneficiaries and one or more remainder beneficiaries, often consisting of a class or several classes of which some or all of the members are likely to be unborn or presently unascertainable, such as remainder to my descendants leaving at termination, and if none, then the X's, then to X's, then living descendants. B, classification of trust. Method of classification, number 1, section 9. A trust may be classified in several different ways according to A, the duties imposed on the trustee, active versus passive trust. B, the trust purposes, private versus charitable trust. The manner of creation, express, resulting, and constructive trust. D, the time of creation, inter vivos, living, or testamentary trust. Living trust may be irrevocable or revocable and amendable in whole or in part. Exam tip. The classifications above are important as they may affect the substantive rules that govern the validity, creation, and operation of the trust and the rights of the parties. Active versus passive trust. Based on duties, section 10, A, trusts are classifiable as active or passive according to the duties imposed on the trustee. 1, active trust, section 11. Trust in which in addition to holding title to the trust property, the trustee has some affirmative duties of management and administration to perform. And this is the typical modern arrangement with which the subject of trust is primarily concerned, our act of trust. I'm going to read that again, and I apologize for my stumbling. I'm going to read it again. Okay, active trust. Trust in which, in addition to holding title to the trust property, the trustee has some affirmative duties of management and administration to perform. And this is the typical modern arrangement with which the subject of trust is primarily concerned, our active trust. Number two, passive trust. Trust in which the trustee has no real duties but holds, i.e., is a mere receptacle of the legal title on behalf of another, are passive trust. B, historical background. Uses. The early predecessors of trust were once important in conveying title to land, or even in concealing ownership, or in circumventing policies, rigidities, or deficiencies in the law. Prior to the Statute of Wills, 1540, an owner could not pass title to land by will to his heirs or others. Consequently, to pass land to the intended successor, the owner would convey it inter vivos to a third person to the use of the conveyor during the balance of his life, and thereafter to the use of his intended successor. 1. Effect. The use so created was a passive trust. The trustee had no duty but to hold and convey title as directed by the designated beneficiary. Number 2, note. During earlier periods, uses and trusts were said to be purely honorary. They were not enforceable at law because no writ existed for the purpose. Later, Chancery, as the court of conscience, began to enforce uses. I'm going to read that again. During earlier periods, uses and trusts were said to be purely honorary. They were not enforceable at law because no writ existed for that purpose. Later, Chancery, as the court of conscience, began to enforce uses. Statute of Uses. C. The Statute of Uses was enacted in 1536 in an attempt to eliminate this method of holding or passing title. The statute provided essentially that when a person was thereafter seized of land to the use of another, the latter would be deemed the complete legal and equitable owner, and the former, often called the fief, the fiefy to uses, would have no interest in the property. The statute transformed executed uses automatically, converting the beneficiary's interest into legal interest by operation of law and eliminating the interest of the initial grantee of the legal title. Number 1, purpose, section 15. The purpose of this statute was to discourage the holding of title in ways that involved concealment or avoidance of rules and policies of the time. The statute sought to execute the use immediately so that the beneficial equitable owner would be regarded as the full, i.e., also legal owner. Ineffectiveness, number 2, section 16. The statute of uses, however, did not eliminate all uses because either as a result of its express provisions or because of the interpretation given to it by the courts, certain equitable interests were not converted into legal interests. Specifically, one, the statute had no application to equitable interest in personal property. Two, it was exhausted without executing the second use, where the transfer or the transferor created a use upon a use. Two, where A conveys to B to the use of C to the use of D. B's title is executed and passed through to C, who now has the legal title but continues to hold to the use of D, whose interest remains equitable. And three, the statute was held to have no application to active uses in which the FOFI had affirmative duties of administrative involving the operation of management of the land for the benefit of the cestacade use. Let's look up FOFI. Affowment of land to one person to the use of another. So it's basically like a transfer. Affowment, the gift of any corporal hereditament to another, operating by transmutation of possession and requiring as essential to its completion that the cession be passed, which might be accomplished either by investitures or by livery of season. A gift of a freehold interest in land accompanied by livery of season. The essential part of the livery of season. Also, the deed or conveyance by which such corporal hereditament is passed. Affowment originally meant the grant of a feud or fee, that is, a barony or knight's fee for which certain services were due from the fofi to the fofer. By custom, it came afterwards to signify also a grant with livery of season of a fee of a free inheritance to a man and his heirs, referring rather to the perpetuity of the estate than to the only method in ordinary use for conveying the freehold of land in possession, but also now falling in great measure into disuse, even in England, having been almost entirely supplanted by some of that case of conveyances founded on the statute of law of the realm, both meant to uses, both for the person making of fofment or in fofing another in fee. In such case, the fofee was bound in conscience to hold the lands according to use and could himself derive no benefit. Sometimes such fofments were made to the use of the fofer. The effect of such conveyance was entirely changed by the statute of uses. Okay, that's the reading. Okay. Ineffectiveness. The statute of uses, however, did not eliminate all uses because either as the result of its express provisions or because of the interpretations given to it by the courts, certain equitable interests were not converted into legal interests. Specifically, one, the statute had no application to equitable interests in personal property. Two, it was exhausted without executing the second use, where the transferor created a use upon a use, where A conveys to B to the use of C to the use of D. B's title is executed and passed through to C, who now has the legal title but continues to hold to the use of D, whose interest remains equitable. And three, the statute was held to have no application to have active uses in which the FOFI had affirmative duties of administrative or administration involving the operation or management of the land for the benefit of the cestui que use. 3. Chancery, Section 17. Those combinations of unexecuted legal interests and beneficial equitable interests that were not converted into legal interests received recognition and enforcement by the courts of chancery. These relationships evolved into the modern trust device, and the principles of recognition and enforcement fashioned in chancery came to form the basis for the law of trust. D. Passive trust in modern law, number 18, or section 18. The execution of passive or dry trust is still a part of the law. The statute of uses, as one of the common law statutes, is considered to be a part of the common law of most American statutes, even in states where it is recognized as such, possibly California. See a state affairs 132 Cal 523 1901. Similar results are reached typically with respect to personal property by analogy, as well as to realty, either by statute or by judicial decision. See Reed versus Brown, 292 New York 184 1946. Active trustee, section 19. In general, a trust will be treated as active if by its terms the trustee has any power or duty that involves the exercise of discretion in active management or in determining the rights of the beneficiary. The typical modern trust involves a broad array of management authority and responsibilities and some discretion over distributions, such as a power to invade principal for the life beneficiary. Number 2, passive trustee, 20, section 20. If the only acts to be performed by the trustee are purely mechanical and formal in nature, the trust will be regarded as passive and the trustee's legal title will pass through to the beneficiary, who will hold both legal and equitable title, i.e., there is no trust. A. Duty to hold and convey, section 21. Where a trustee's duty is merely to hold and convey title, the duty to convey is not considered by most authorities to be an effective or an active duty, and the trust is usually regarded as passive. Everts versus Everts, 45 NW 88, Michigan 1890. A trustee may have active duties with respect to the life interest, but not with respect to the remainder, so that the statute of uses or court or counterpart doctrine may operate on the remainder alone, either initially or at the end of the life interest, where the remainder is executed at the outset. The trustee may hold a legal life estate per ultra v for the life of and for the benefit of the life beneficiary, with a legal remainder interest in the remainder beneficiaries. This rarely happens today because the trustee's powers to sell and encumber trust assets require full title. Execution would thus occur at the life beneficiary's death. Number 3, private versus charitable trust. Section 22, where the trust purpose is to confer certain benefits upon the public at large or upon some significantly large segment of the public to be deemed charitable. See Infra Section 502 to 512. The trust is classified as a charitable trust, and language and rules are liberally interpreted and applied to give effect to the settler's wishes. See Infra 504. Other trusts are considered to be private trusts and are subject to more restrictive substantive rules. Number 4, express trust versus those created by operation of law, Section 23. Trusts are also classified according to the manner or basis of their creation. Some trusts are intentionally created by the parties, this legally ascertained intent being expressed or inferred, i.e., founded in the settler's words or conduct. Others are recognized, implied, or imposed by operation of law, even when no actual trust intention existed at all or with respect to the particular interest being established. A. Express trust, Section 24. An express trust is created as a result of the manifestation of an intention by a person or persons having the power to do so, to create that relationship that the law recognizes as a trust. Trust terminology need not be used or even known to be or to the purpose involved. Let me read that again. Trust terminology need not be used or even known to the persons involved. The required manifestation of intent may be found in the settler's oral or written words, conduct, or a combination of these viewed in an oral context. Most matters discussed in this summary primarily involve express trust or of active variety, private or charitable, testamentary or inter vivos, revocable or irrevocable. Resulting trust, Section 25. A resulting trust is based on the legally presumed intention of a property owner, as distinguished from the actual intention involved in express trust. It arises by operation of law, where an express trust fails in whole or in part, or where the beneficial provision of an express trust are incomplete, i.e., the settler failed to make full disposition of the equitable interest. The trustee is then said to hold upon a resulting trust for the settler or for successors in interest. Therefore, in most instances, it is helpful to think of a resulting trust simply as the consequence of an equitable reversionary interest becoming realized. Closely related is the purchase money resulting trust. See Infra Section 11, 1011 through 1020. Construction or constructive trust, see Section 26. A constructive trust is really not, in a strict sense, a trust at all. It is a remedial device invoked by a court in the exercise of its equitable powers. Its purpose is to compel a person who has obtained property by wrongful means, including in most jurisdictions through unjust enrichment as the result of mistake or the wrongful behavior of another. To turn the property over to the party entitled to it. Thus, a constructive trust is not necessarily predicated upon any actual trust intention, but is imposed by a court, implied by law, to redress fraud or other wrongful conduct, or to prevent unjust enrichment. This restitutionary device is broadly applicable to transactions having nothing to do with express trust, but it is also applied in cases where an intended express trust cannot be enforced as such, but where the law will intervene to prevent a trustee, the intended trustee, from benefiting from the unenforceability, such as where an oral promise to hold in trust is unenforceable by reason of the statute of frauds. Constructive trusts are discussed in more detail. Infra 1040 section 1047 et seq. C. Trust distinguished from similar relationships. Characteristics, not terminology controlling. Section 27. Similar arrays of rights and responsibilities, including fiduciary duties and obligations, may be found in a variety of other relationships that are, in varying degrees, somewhat similar to trust, but which lack one or more of the essential characteristics of a trust. It is often difficult to ascertain whether the parties involved intended to create a relationship that is recognized in the law as a trust, because the use or the failure to use the trust terminology is not conclusive of the parties' intent. See generally restatement 3D, section 5. 2. Bailment, where the owner of tangible personal property gives possession but not title to another, the relationship is one of bailment. If the property owner delivers a chattel to another, the benefit the owner or a third party, this may come close to a trust, but it may actually constitute some other form of relationship. A guide for distinguishing. A court will first attempt to determine whether the owner intended to pass title as well as possession in assessing whether the recipient is a trustee or a bailee. If the owner's intention is unclear, an important factor is whether the owner's purposes in delivering the chattel could have been affected by a transfer merely of possession. B. Principal differences between bailment and trust. Nature of the property, section 30. A bailment pertains only to chattels, although a comparable interest in land might be a leasehold. A trust may exist with respect to real or personal property, whether tangible or intangible. 2. Title, section 31. The bailor, owner, retains both legal and equitable title. The bailee merely has a right to possession. In a trust, legal title is in the trustee. The settlor does not retain title unless it is an equitable interest retained as a beneficiary, or unless she also serves as trustee and thereby takes title in her fiduciary capacity. A transaction, however, that would obviously raise no bailment question. Example, transferor hands her diamond bracelet to transferee, telling transferee to give this bracelet to my daughter. I'm sorry, let me start that over. Transferor hands her diamond bracelet to transferee, telling transferee to give this diamond bracelet to my daughter when she returns from Europe. If transferee is bailee, She merely has a right to possess the bracelet. The bailor retains title. If transferee is a trustee, she has legal title to the bracelet. 3. Transfers. Lacking title to the chattel. A bailee cannot ordinarily convey title to another, i.e., even a sale of a bona fide purchaser would not cut off the bailor's interest under common law principle. The Uniform Commercial Code changes this rule in certain situations. See Sale and Lease of Goods Summary. A wrongful sale of the trust res by a trustee to a bona fide purchaser, however, usually does cut off the equitable interest of the beneficiaries. Under common law principles, the transfer of legal title to a bona fide purchaser cuts off latent hidden equities. 4. Income. Section 33. Rents, issues, and profits from the trust res belong to the beneficiary, whereas the rents, issues, and profits from bailed chattels ordinarily belong to the bailor. 5. Remedies. Section 34. The rights between bailor and bailee are usually enforced at law, although if unique chattels are involved, equitable relief may be appropriate and available. The duties of a trustee are enforced in equity. 3. Subsection 35. Agency. An agency often appears very similar to a trust, and the duties and obligations of an agent holding property for a personal or for a principal are similar to those of a trustee. Rizos versus Zam and Nagel Company. A, guiding for distinguishing or guide for distinguishing. Subsection 36. There are, however, various distinctions between an agency relationship with regard to property and a trust relationship. These distinctions are of significance both as possible subsequent consequences of the distinction and as possible aids in understanding and identifying which relationship is involved. I'm going to read that again, and please forgive my stumbling. So, A, guide for distinguishing, section 36. There are, however, various distinctions between an agency relationship with regard to property and a trust relationship. These distinctions are of significance both as possible consequences of the distinction and as possible aids in understanding and identifying which relationship is involved. One, title. A trustee has a title to the trust property. An agent may or may not hold title on behalf of the principal, but the holding of title is not an element of an agency as such. 2, control. An agent is subject to the control of the principal, but a trustee is not subject to the control of either the beneficiaries, although they have power to enforce the trust or the settlor as such, although the settlor's reservation of powers of revocation, amendment, or direction may give her effective control or some measure of control over the trustee. Powers. An agent's authority is limited to what is granted by the principal and tends to be quite strictly construed. In addition to powers expressly granted by the terms of the instrument, a trustee's power tend to be rather broadly construed. Except as limited by the settlor or by law, a trustee generally has powers necessary or appropriate to carry out the purposes of the trust, and under the modern view, all of the powers of an outright owner. See Infra 606, 610, 621 through 661. Restatement 3D, Section 85. Number 4, liability. An agent acting with the scope of his authority and who discloses the agency normally incurs no personal liability. Rather, the principal alone is liable for any contracts or debts thus incurred by the agent. Under the traditional view, a trustee is ordinarily personally liable to third parties for his acts on behalf of the trust, even when acting properly. He cannot subject the beneficiary or settlor to these liabilities without their consent or participation, but does have a right of reimbursement or exoneration from the trust estate for liabilities properly incurred. Note, this traditional doctrine concerning trust has evolved in the direction of recognizing the trust as an entity, with the trustee's liability being not personal but representative of the trust, a view that is reflected in many statutes and encouraged by the Third Restatement and the UTC, Section 1010. Termination, Section 41. An agent's power terminates on the death or, except in the case of a durable power of attorney, incapacity of the principal. A trustee's power does not depend on the settlor's competence or survival. Example, uncle delivers $25,000 to nephew to distribute to certain of uncle's relatives. Nephew fails to do so prior to uncle's death. If nephew is only an agent, the $25,000 belongs to uncle's estate, and nephew no longer has power to make distribution among the relatives. State ex rel. Teague versus Home Indemnity Company. If nephew is a trustee, the distribution is to be made despite uncle's death. Okay. Debtor-creditor relationship. A debt differs from a trust in that, although the creditor may have a claim against the debtor personally, the creditor has no interest in any specific property or the debtor at least until judgment, or unless the creditor has a security interest, in which case the rights are still quite different from those of a trust beneficiary. See Restatement 3D 5, Section 5 CMT. A. Guide for distinguishing. Note, notwithstanding some obvious distinctions, it is sometimes difficult to tell whether a debt or a trust relationship was intended in a given situation. The crucial distinction is usually whether the parties intended to create a relationship with respect to specific property. Example, transferor hands transferee a bundle of $20 bills totaling $500 and indicates that she wants the money returned at a specified date. If, as is likely, transferor does not care whether she gets back that particular group of bills or even property directly traceable to them, the arrangement cannot be a trust but is simply a debt. Thus, transferee can repay transferor any $500 and is free to dispose of the particular bills received. Example, an employer withholds a portion of each employee's pay with the understanding that the employer is obligated to deposit certain amounts in an employee's pension fund. The employer probably has a debt for this amount, rather than holding certain properties in trust, as long as the withholding did not involve identifying and setting aside particular dollars. The expectation would be that the employer is to make the deposit at the appropriate time from any funds available. McKay versus Paradise. Compare. When a party is obligated to hold for the benefit of another specific funds received from a third party, the result will usually be that the funds constitute property held in trust. Kramer versus Worldwide Trading Company. 305, 1921. Agreement to pay half of funds received from certain ship sales as commission held to be a trust. Agreement to pay half of funds received from certain ship sales as commission held to be a trust. 1. No, interest payment denotes debt. If the transferee is obligated to pay interest or some agreed substitute thereof, this is virtually conclusive that the relationship is a debt. The fact that the interest or the principal is to be paid to a third party is not likely to matter. If, however, the transferee can only promise to pay whatever interest or income the money earns when deposited into a savings account or invested, the relationship is more likely to be a trust. Consequences of distinction between debt and trust. 1. Insolvency. Section 45. If transferee is merely indebted to transferor and transferee becomes insolvent, transferor would have the same status as any other creditor. If, however, transferee is trustee of funds received from transferor, transferor could claim those funds or trace them into other identifiable assets and thus obtain property or priority over other creditors and in fact have an exclusive right to the trust property. 2. Profits. Section 46. If a debt is involved, any profits realized on transferee's investment of the funds normally belong to transferee. Transferee merely has an obligation to repay the amount owed to the transferor, including any agreed interest. On the other hand, if the funds were held in trust, the profit would belong to the beneficiaries and not to the trustee. 3. Losses. Section 47. If the relationship between transferee and transferor is a debt, transferee owes the amount in question to the transferor, regardless of any losses sustained through the investment or theft. Bruner versus Edward. If the relationship is a trust, losses from investments or theft merely diminish the trust, res, i.e., the beneficiaries bear the loss. The transferee is not personally liable as long as he conformed to the appropriate fiduciary standards of care, etc., in managing and caring for the property. If transferee had been negligent as trustee, transferor could hold him liable by way of surcharge. If the loss resulted through no fault of transferee, the party who will bear the loss will depend on whether the relationship was one of debt or trust. Equitable charge. Subsection 48. The owner of property may devise it by will or transfer it inter vivos to another, subject to an obligation to a third person. In such a case, the third party may be held to take the property subject to an equitable charge or lien. Restatement 3D 5 CMT. H. An equitable charge is like a trust in that equitable property rights are vested in the beneficiary, but it is merely an encumbrance or lien against the property, whereas the beneficiary's interest in trust property actually involves equitable ownership of the property. Downer versus Church, 1871. Example, transferors devises Blackacre to transferee, subject to transferees paying by debt to friend, subject to transferees paying my debts to friend. Transferee holds full legal title, subject to an equitable charge in favor of friend. Guide for distinguishing. Section 49. Whether a transfer results in a trust or equitable charge ultimately depends on the transferor's intent. If the transferor intended to impose duties on the transferee to deal with the property for a third person's benefit, a trust is created. But if the transferor intent was only that the property stand as security for payment of a sum of money to a third person, an equitable charge is created. Number 1, terminology, Section 50. Phrases such as subject to payment of or upon condition that she pay suggest an equitable charge rather than a trust, but are not conclusive. Parole evidence. Section 51. Parole evidence concerning the relationship of the parties is admissible to help ascertain the transferor's intent. Number 3, other considerations. In attempting to classify the transaction, it is relevant to consider whether it appears that the transferor contemplated that the property could be used by the transferee for her own benefit without an accounting, subject only to the obligation to make the agreed payments. A trustee generally cannot use the property for her own benefit and is subject to an accounting. Example, transferors convey Whiteacre to transferee, subject to transferees paying all monies needed for beneficiaries' education. Absent evidence to the contrary, most courts would probably hold that transferor intended not only that the property stand as security for transferee's obligation to beneficiary, and hence only as equitable charge was created. Compare. If the grant had been made, quote, upon condition that transferees sell the property, end quote, invest the proceeds, and then them and their income as indicated, it would probably be held to be trust, because then it would appear that transferor intended to impose upon transferee the duty to deal with the property, at least in part for beneficiaries' benefit. Incidentally, unless it is found as a matter of construction that an excess over what is provided for beneficiary is to be retrained for transferee's personal benefit as the additional beneficiary, the excess would be held upon a resulting trust for transferor's successor in interest. Comparison of trust and equitable charge. Title, Section 53. The beneficiary of a trust is the equitable owner of the property. Although legal title is in the trustee, the beneficiary of an equitable charge is not the owner, legal or equitable, having merely a lien on the property, which is otherwise owned by the transferee, and surplus thus belongs to the transferee rather than being held upon as a resulting trust. Let me read that again. So, comparison of trust and equitable charge. We're talking about title, Section 53. The beneficiary of a trust is the equitable owner of the property, although legal title is in the trustee. The beneficiary of an equitable charge is not the owner or equitable. The beneficiary of an equitable charge. The beneficiary of an equitable charge is not the owner, legal or equitable, having merely a lien on the property which is otherwise owned by the transferee. Any surplus thus belongs to the transferee rather than being held upon a resulting trust. So, oh, this is really getting good. Subsequent transfer, Section 54. If the holder of the title conveys to a bona fide purchaser, this can cut off the equitable charge, just as it can cut off the beneficiary's interest in a trust. Note, however, that where a deed to real estate is involved, the beneficiary in either case can be protected by a proper recording, which serves to put subsequent purchasers on notice of the beneficiary's interest. Some liens on personal property may also be recorded under Article 9 of the Uniform Commercial Code. Income, number 55, or Section 55. Income of a trust belongs either to the income beneficiary or to the other beneficiaries, whether they need it or not. The beneficiaries, including, if need be, the grantor as beneficiary of a resulting trust interest, are the equitable owners. However, the holder of an equitable charge has a lien on all property, including its income, but no rights to the income as such. Number 4, remedies. As a general rule, neither the trustee of a trust nor the grantee of property subject to an equitable charge is personally liable for making the payments in question. The beneficiary of a trust enforces his rights by a suit in equity to compel the trustee to perform her duties, but so long as no misfeasance is involved, only the trust property is responsible. The holder of an equitable charge enforces his rights simply by foreclosing his charge or lien against the property, unless the charge expressly or impliedly imposes personal liability on the grantee if she fails to perform. Number 5, fiduciary duties. There is a fiduciary relationship between trustee and beneficiary, but not between the holder of an equitable charge and the transferee of the property. This factor may be important in analyzing dealings between the parties, such as whether one owed a duty to the other to disclose material facts concerning value of the property. 6, conditional fee, Section 58. A condition in a grant for the benefit of the grantor or a third party may at times suggest may suggest a trust relationship. For example, a conveyance from father to son upon condition that son support brother for the rest of brother's life could conceivably be construed to: 1, impose a trust; 2, create an equitable charge on the land; or 3, create a determinable fee or fee subject to a condition subsequent. Witcher versus Abbott, 1982. Consequences of distinction. Section 59. Where title is held as determinable fee or a fee subject to a condition subsequent, any failure, breach of condition subjects to estate to termination and entitles the transferor or his successors in interest to recover the property. A failure of a trust duty, however, entitles the beneficiary to sue in equity to compel the trustee to perform his duties. B, role of construction. Generally, courts are reluctant to give words of condition literal effect where forfeitures on failure of the condition would result. See property summary. Hence, unless the language makes clear that a condition was intended, a grant will usually be construed as creating a trust or equitable charge rather than a conditional fee. Restatement 3D 5 CMTH. This is particularly so where the condition is for the benefit of someone other than the grantor, inasmuch as the breach of a condition would give the one intended to benefit no legal or equitable remedy. The property simply reverts, whereas the beneficiary of a trust equitable charge has equitable remedies. I might need to read that again. Generally, courts are reluctant to give words of condition literal effect where forfeitures or failure of the condition would result. See property summary. Hence, unless the language makes clear that a condition was intended, a grant will usually be construed as creating a trust or equitable charge rather than a conditional fee. Restatement 3D, Section 5, CMTH. This is particularly so where the condition is for the benefit of someone other than the grantor, inasmuch as the breach of a condition would give the one intended to benefit no legal or equitable remedy. The property simply reverts, whereas the beneficiary of a trust or equitable charge has equitable remedies. Other relationships, Section 61. Number 7. Various other fiduciary relationships may at times appear similar to trust, such as guardianships, receiverships, the positions of executors or administrators of estates, even corporate directorships, partnerships, or limited liability companies. Each of these differs from a trust in some or all of the following. Distinguishing characteristics of trust and non-trust relationships. So trust. Transferee holds legal title to specific property for benefit of one or more persons who hold equitable title. So X devises property to T in trust for Y. T holds legal title, Y holds equitable title. Bailment. Transferee has possession but not title, which means that X leaves her car with a mechanic for service. X retains both legal and equitable title because she just left it with the mechanic for service, which is a bailment. Agency, example is a transferee is subject to control of a transferor. So X tells Y to deliver a diamond necklace to Z. X until delivery is complete. So X is holding the title until it's complete. Okay, so debtor, creditor. Transferee is entitled to unrestricted use and disposition of property, i.e., no duty to segregate, subject to repayment to transferor. Okay, so X loans Y $10,000 with repayment plus 10% interest due in 12 months. Y, X's rights are as a creditor. X is a creditor. Y is the debtor. Right. Equitable charge. Transfer intends only that property stand as security for payment to another. So equitable charge. X gives property to Y subject to Y's paying Z. X gives property to Y subject to Y's paying Z's debts. So Y is subject to Z's lien. Conditional fee. Failure of conditional fee results in forfeiture or termination of estate with no legal or equitable remedy for transferee. X conveys to Y upon condition that no alcohol is served on the premises. Y, but if X is served on the premises and X exercises her right of reentry, see property summary, Y's interest terminates and X regains full title. Y has no recourse. Respect the natures and characters of title held by the fiduciary, the duties and powers of the fiduciary, and the remedies available for enforcement. Other bodies of law also deal with special uses of the trust device, such as real estate investments, real estate investment trust, or REITs, voting trust, Massachusetts Business Trust, and Employment Benefits Trust, none of which are dealt with specifically in this summary. Okay, so that includes the reading for chapter 1, you guys. I will return with chapter 2. Thank you for listening. I hope you enjoy. I hope you are not frustrated by my stumbling or rereading, and that you appreciate my reading. Thank you so much.